All right. Well, thank you for joining us in the TMA today for the preferences and fraudulent transfer overview. My name is Ron Spinner. I'll be your host today. We're going to go through these actions because I think the TMA has felt that with all the upheaval in the economic situation, interest rates, inflation, supply chain, whatnot, bankruptcies are coming, and with bankruptcies, there tends to come avoidance actions. And so it's best if we all get ahead of it and have an idea of what they are. For those who are familiar, this will hopefully be a useful review and maybe a few tidbits you didn't know. And for those who are not familiar, this should be a great primer and starter to help you be prepared for what's coming. At the end, we'll talk about the three main areas of preference, fraudulent transfers, and post-petition unauthorized transfers. And we'll talk about how one settles them for practitioners so they know what's to be included in the settlement, what's not to be included. And we'll give some tips for people who have corporations so they have an idea of what they might do to avoid issues. Before we get started too far in, we should remind people that this is indeed a free seminar. This is free to members and guests, and it's free because of the people you see on the screen. Please take a moment and take a note of the people or the organizations you see here, especially recognizing the ones that you're familiar with. And as you go forward and trying to make your business decisions, helps to know that these are the people who are trying to bring information to practitioners and others free of charge so we can all do our very best in our daily lives. Upcoming events. We have a networking event coming up next month. Keep your eyes open for that. We're going to be meeting with the Risk Management Association, mixology and cocktail tasting. More news will come pretty shortly, I expect, in your email box. Also coming up in March, the Mid-America Regional Conference, also known as MARC. It's hosted each spring by the Chicago and the Midwest, Detroit, Minnesota, Ohio, West Michigan chapters. This year it's taking place in Minnesota. It features keynote speakers, a showcase, and a nightcap reception. So this one is going to take place, I believe, in Minneapolis. Also coming up in May, a TMA Detroit annual award ceremony. This is where we recognize people who have helped in the biggest, well, the smallest, medium size, and the biggest turnarounds and liquidations and otherwise trying to get people back on their feet. Stay tuned again for more information on that upcoming. A little bit about me. I am principal at Miller Canfield's Bankruptcy Group. I specialize in bankruptcy litigation, especially fraudulent transfers and preferences, which is why I'm presenting today. Also, recently authored an article called Decrypting Crypto. It's to help bankruptcy professionals understand how cryptocurrencies should be treated in bankruptcy. If you have access to Westlaw and the Norton Journal of Bankruptcy Law and Practice, you can access it there. If you do not, and you wish a copy of the article, my email there is below, spinner@millercanfield.com. If you send me an email, I'll be happy to send you a copy. Likewise, if you have questions today, I'm going to try to monitor on the side panels here, the chats and Q&A. I'll try to answer questions as I can at points along the way. If you have questions that don't occur to you or you don't get a chance to have your question addressed, my email is there, spinner@millercanfield. Feel free to reach out and I'll do what I can to help. All right, so what are we going to do today? We're going to talk briefly about, first, an overview of the three types of avoidance actions that are preferences, fraudulent transfers, and unauthorized post-petition transfers, just to give you an idea of where they came from and the basics about them. Then we're going to dive more deeply into preferences and fraudulent transfers, as those are the ones that affect people more or less in a day-to-day life. You'll find they're also called fraudulent conveyances and voidable transactions because state law, the uniform laws on fraudulent transfers have taken many names over the years. They're all basically the same thing. And as I said, for practitioners, we'll talk about how one approaches settlement of these topics and what you do and do not want to have within a settlement. And for people who run a business, how do you prepare for them? So let's dive in and start talking about avoidance actions generally. First, preferences. People love to hate them. Where do they come from? Apparently, Old English law in the 1700s. And the principle is pretty simple. If a debtor knows that he can't pay everybody, it's going to pay the people that it has to. So if you have a debtor, for example, and it has a landlord and it has a supplier, and the supplier will not ship goods without being paid, but the landlord's going to take some time before it can evict the debtor's going to pay the supplier. It's going to prefer, in terms, the supplier, and everybody else loses out. When the bankruptcy actually is filed later, The supplier will have gotten something, whereas the landlord will have gotten nothing. And that's considered preferring one creditor over another. Now, English judges felt that this was unfair because in the bankruptcy code, similarly situated creditors, by which they mean creditors who have the same lien rights, in this case, they're all unsecured, should all be treated about the same. So wouldn't it be fair if everybody just sort of kicked money back into the pot and we split it up equally so everyone receives about the same? Very moral, very fair sounding. And in 1746, England passed a law to try to make that work. Well, here's the problem with that, is that if you know that if you deal with somebody in financial distress that you may have to give the money back, who's going to want to deal with people in financial distress? And of course, if everybody flees from the people with that financial distress, then they're going to file bankruptcy that much faster. So you can't have that, right? So we put up defenses for honest creditors who are not trying to pressure a debtor. That way people have an incentive to continue working with people in financial distress. But now you have kind of a complicated mess because you have people asked to give their money back. Nobody gives money back on their own. You have to sue them. So you got lawsuits involved. You've got defenses that are complicated and arcane. And what starts out as a very great moral sounding high road idea becomes in practice a complicated mess. And that complicated mess is in the bankruptcy code under Title 11 at Section 547. 547B of the code gives you all the things that a transfer must be in order to be a preference, and 547C has all the defenses. So for something to be a preference, it must be a transfer of the debtor of an interest in its property, and generally speaking, that interest is going to be money, but it could be something else. It has to be to or for the benefit of creditor. It's got to be on account of an antecedent debt, means a debt that you owed, not a prepayment. Got to be made while the debtor was insolvent, i.e. it doesn't have enough money to pay its debts. And the law presumes this to be true, although it can be rebutted. And then it has to be within 90 days of the petition date. This is the time that Congress has decided people kind of know when they're in trouble. If you're an insider, you probably have more knowledge, so they extend that period back out to a year. And then it has to allow a creditor to receive more than it would in a Chapter 7 bankruptcy. Basically, it's a no harm, no foul rule. If you're a secured creditor and you would have gotten everything the same amount, whether you're in the bankruptcy or not, then there's no real reason to allow a preference action. And of course, 547C has the defenses we talked about or will be talking about. The fraudulent transfers. Again, America gets a lot of its law from Old English law, and the Old English judges felt that it was not fair to give away your stuff if you owe money to others. And this is not just bankruptcy law. This is part of most states' laws. Most states, I think all states, have adopted some version of a fraudulent transfer act. And a debtor's transfer is considered fraudulent in two circumstances. One, if you're actually trying to commit fraud. If you know somebody's after you and you're trying to give your stuff away so nobody can get it, you're trying to hinder or defraud a creditor, that's a fraudulent transfer. But it doesn't have to actually be intended to be fraudulent. It could just end up acting as fraudulent, even though there's no intent for that. And that's still considered a fraudulent transfer. It's called constructive fraud, meaning it kind of is fraud, but it wasn't necessarily with intent. So what happens in that situation? That's where a debtor gives something away when it owes money and it can't pay its debts, and it doesn't get back reasonably equivalent value as a result. That's essentially the basics of it. So those things, remember, I said preferences are at Section 547, fraudulent transfers are at Section 548 of the Bankruptcy Code. 548A1A is the actual fraud stuff we talked about. If you're trying to commit fraud, you gave your stuff away, or you take on new debt, new obligations without any intention to pay them, and you're intending to defraud, that's under A1A. Now, A1B is the constructive fraud. That's where the debtor gives away something and receives less than equivalent value for it. And one of a couple of things has to happen. Either has to be insolvent, meaning you don't have enough money to pay your debts, or become insolvent as a result of giving your stuff away, or you're in business and you don't have enough money to run the business when you make this transfer, or you're intending or expect to incur more debts, so you know something's coming. Basically, these are the situations where a debtor shouldn't be giving away its stuff. Now, it's not just Section 548 of the Bankruptcy Code that allows fraudulent transfers to be pursued. You can also look to Section 544B, which allows a debtor to use all state law fraudulent transfer laws. And like I said, every state's got something. This is important for people mainly for one big reason. The Bankruptcy Code looks back 2 years. It can undo a transaction that's 2 years prior to the date the petition is filed for bankruptcy. But the state laws go back further. The default in most, if people enacted the uniform laws as proposed by the Uniform Law Commission, they would go back 4 years. But almost every state monkeys with that. Some go 3, some go 4. Michigan goes back 6 years. So by using state law, they can go back and undo things 6 years ago. And that's a long time for people to have to worry about things. Now, briefly, we'll just touch on this because it's, for matter of completeness. We talked about sections 547 and 548. 549 allows a debtor to avoid any unauthorized post-petition transfers. Once you file bankruptcy, there's a lot of restrictions on what you can do with your money. Now, in Chapter 11, that's not generally a problem because in Chapter 11, the debtor is authorized to continue operating its business in the ordinary course. So ordinary business payments are authorized and can't be clawed back by this. But if you're in a Chapter 7 liquidation where a trustee is appointed and such, the debtor can't basically file a Chapter 7 and start writing checks anymore because it doesn't have control of the funds. And if the debtor does that and somebody cashes the check, that money can be recovered as an unauthorized post-petition transfer under this section. And that's all we're going to say about post-petition transfers because they generally don't come up very often. So we talk about, this is about avoidance, right? This is the avoidable transactions. Avoidance by itself isn't enough. Avoiding a transaction doesn't actually get the debtor any money. What you have to do is you have to recover the avoided transaction, and that's done under Section 550, which allows a debtor to recover the property transferred or with court approval, the value of the property transferred, and it's got to be for the benefit of the estate. Now, keep an eye on this value business because that's going to come up in a bit about with the cryptocurrencies because it may cause some people some heartache they weren't planning on. Now, you can get the transaction, you can recover this voidable transaction from the person who received the property, or if they themselves gave it to somebody else, you can recover it from the person that they gave it to, unless, and here's the big unless, that recipient took the product or the value or whatever the good is for value and received it in good faith without knowledge of the avoidability. So think about the situation, for example, I have a fraudulent transfer where I give my car to my daughter and I'm insolvent, I can't pay my debts. So I give my car away and we'll just say that's a fraudulent transfer because I'm trying to protect it. Now my daughter gives that car to her friend. If she just gives it to her friend and the friend doesn't pay anything for it, you could, a creditor could sue my daughter to recover the transfer or her friend to get that car back. Now, slightly different scenario. My daughter sells the car to her friend. The friend doesn't know anything about what happened. They pay good money for the car and they take it. That's reasonable value for the car. Now, because that friend took the value of the car, you took the car for value, took the property in good faith without knowledge of the transfer being avoidable, you can't sue the friend anymore. What you do is you sue my daughter and you try to get the proceeds from her. So that's the overview. Now we have at least a basic idea of what we're talking about. Let's dive into preferences and how one deals with them. Now, we talked about Section 547 is where these things are coded in the Bankruptcy Code under Title 11. Why do debtors file these things? Well, believe it or not, a lot of people believe they have a duty to the estate. Debtors believe that they owe it to other creditors to file them. Remember, the purpose of this is that you get money from people who got it paid, who got something, and you share it amongst all the people, in theory, all the people who didn't get anything. This is a duty that the statutes provide for it. Many debtors believe that they should be prosecuting these things. Now, there's the more practical reason, and I think the main driver, it gets cash in. Remember, although the idea is to split up the proceeds, you take the money from people who received it and you pay it out to people who didn't, in theory, or to everybody equally, the debtor has to use, it pays out the proceeds, which is net of expenses. Well, what expenses are we talking about? We're talking not just the cost of collection, but the expenses of the bankruptcy estate as a whole. So the debtor can effectively use this to pay its own attorneys and run the estate. If there's enough preference claims out there, they can actually run the bankruptcy estate off of, at least partially off of preference claims and the recoveries from them. And this is what Sears did. It had really, I don't think, any intention of giving much money to unsecured creditors when it filed preferences. It wanted to use the money to pay its attorneys and was doing so. And why else do they do it? Because they can. And no knock to debtors counsel. I tend to be a creditor's attorney, but debtors get advice from their attorneys, and attorneys do make money filing preference cases on behalf of debtors. And if you have a moral, argument that it's a duty to the estate, I mean, that's why these things were enacted in the first place. attorneys don't really feel too much compunction telling a debtor, you got to file these things. At least make a try for the obvious ones. How aggressive they go depends on how the debtor and the debtor's attorneys feel and how much cash they need. But that's the general reason why these things get filed. Also to know, it is not just money. We talk about it's a transfer of an interest of the debtor in property they're trying to avoid. Now, that an interest of the debtor in property, the property is usually money, but it can include granting a mortgage or a lien, anything that secures a debt, because these are interests in property under the law. And if some debtor grants this in the 90 days pre-petition, say to secure a debt, that can be avoided as a preference, and it's not something that people think about. Another thing people aren't thinking about, probably not too many of them, I haven't seen it mentioned too often, really certainly not prominently in these articles, but it can include withdrawal of cryptocurrency from a Celsius earn account. For those of you who haven't been following the news, it's really hard to avoid it because it's almost everywhere. The judge in the Celsius bankruptcy said that the cryptocurrency that depositors put in their earn accounts was actually owned by Celsius. And why was that? It was because the terms of use said, if you put this as a loan, an earn account was an idea where the cryptocurrency depositor would give the money give their crypto to Celsius. Celsius would in fact borrow it, pay them interest on it, and then if they withdrew, they stopped earning interest, and they would earn this fairly significant amount of interest in theory if they did this. Part of the terms of use in the Celsius earn accounts was that if you put money in there, you put crypto in there, you're giving it to Celsius. It's a loan to Celsius, and they own it while it's in the earn account. And the bankruptcy court upheld that and said that indeed the cryptocurrency in the Celsius earn accounts was property of Celsius, and they can use it to fund their estates. Well, what does that mean? If it's Celsius's property and somebody takes it out, it's a transfer of an interest of the debtor in property. So that means that technically all these withdrawals, all these people who think that they got away free. Oh, thank God I got my cryptocurrency out before Celsius filed for bankruptcy. They may find themselves being sued for preferences. And it's going to get worse. And we're going to talk about that in a minute. So how do you defend a preference? Let's say you're a creditor's attorney like me. What do you do? Well, there's really only a few ways, big main chunks of reasons you can use to defend. First, you can say it's not a preference in the first place. If a transfer is not a preference, you can't sue for it as a preference. Okay, well, maybe it is a preference, but if it is a preference, you may have a defense that applies. That's the defenses under 547C, and we'll talk about those in a moment. And then maybe something is a preference, and maybe there's no defense for it, but there's still reasons why you can't have it back. You can say, one, it costs money for a debtor to pursue a preference, and if the estate's going to have to spend money to sue you, you can always say, look, how about you don't sue me, and I'll give you back some of it. We'll split the savings or something like that. A convenience discount, if you will. Or you got to remember where the defendant might be. I've had a defendant or two in China, and people try to sue them there. It's really hard to sue for preferences in China. You can sue them in the United States, and maybe there's jurisdiction, maybe there isn't. But to get it collected, you're going to have to go over to China and persuade a Chinese court having everything translated into Mandarin or whatever the particular local dialect is. That's a lot of work, and it's got a very uncertain recovery. So, maybe you ought to go away, or maybe you ought to take less than the full amount, even if you think you've got a great law argument under U.S. law. And there's always pleading poverty. If you don't have it, they can't get it. You can't get blood from a stone. If they get a judgment, all it's going to do is put you in bankruptcy. They're not going to collect it. And if they understand that, that's a reason not to pursue you. So let's talk about these three. The first one, again, trying to show that something is not a preference. Now, something is not a preference if it doesn't meet one of the main qualifications we talked about. Remember, it has to be a transfer of an interest of the debtor in property, right? Well, what if it's not the debtor's property? And one of the things that we see all the time here in Michigan is earmarking. This happens when, let's say, an OEM, Ford or Chrysler or GM or Stellantis, they say, I want a supplier to build me something, and that supplier is going to need a tool. And the supplier is the one that's going to go order the tool. So let's say, GM says to the supplier, go get this tool. You probably can find it from this particular party. So that supplier goes off and finds the tool maker and tells them what they need. That they put an order in. The tool maker makes the tool, sends the supplier the invoice. The supplier then turns around to the OEM and said, I got the invoice. And the OEM says, all right, how much is it? And they send a check for that amount to the supplier, and then the supplier sends it off, the same money off to the vendor of the tool. Later on, the supplier files bankruptcy and tries to sue the tool maker for a preference. And this has come up a number of times. I've defended on this ground. You say it's an earmark. If you have evidence, and usually a couple emails will do, showing that the money really didn't come from the debtor, came from the OEM. The debtor was just sort of a go-between. Even if the debtor deposited a check and then wrote its own check, really, the legal fiction is that debtor really never took possession to it, because the debtor was really just acting as a pass-through to the vendor. And courts will accept that. Many of them will. And if they do, it's not a preference. If it's not a preference, you have a defense, essentially. Now, there's a variant of that on the other end, too. If a debtor pays money, and it pays money to a party who's not collecting on its own behalf, but it's collecting for somebody else, and then sues that person, that entity for a preference, they could say, I'm just a mere conduit. It wasn't for me. It wasn't to or for my benefit. And you see that sometimes with advertising agencies, where they're collecting for somebody else. Now, advertising agencies can get complicated, because you have situations where the advertising agency wants to take a cut, right? So because that's their job. And some of that money really does go to them. And then the case law gets a little mixed. Some people say, well, you're not a conduit if you're the one who is owed. Some courts, I've actually seen case law where they say, well, okay, if you have a 3% commission, 3%, that part you're not a conduit, and you can sue for that if it qualifies as a preference, and the rest you're not. It gets messy, but you can get the general idea. If it's not transferred to somebody to or for their benefit, if they're not the creditor, then they're not going to be necessarily the person you can recover from. What about prepayments? If something is not on account of a debt, if it's a prepayment, then it's not a preference. And my favorite example of that is, I had a client in the Radio Shack bankruptcy who 100 days prior to the bankruptcy being filed, switched Radio Shack to prepayment. 100 days. Remember, the look back period is 90 days if you're not an insider, which basically means for all of us, unless you're really part of the debtor's, general inside circle. So because they were prepayments 100 days in advance, nothing that person transferred, and there was millions of dollars of transfers, all prepayments. They even went to the point of even stamping it on the invoice, prepayment on the invoice. And so when the debtor sued for the preference, I showed them the invoices and said, it's not on account of a debt. They're like, who does this? Well, if you have a really good client, who's really smart and on the ball, that makes it really easy to defend. It wasn't a preference. If a creditor is not going to lose anything in a Chapter 7, it's also not a preference. This is like a secured transaction, like if I, for example, have a line of credit with a bank, right? And I have a mortgage on my house, and let's say I have a $500,000 house and a $100,000 mortgage, and I make payments on the mortgage. In a Chapter 7, the creditor would have the trustee liquidate my house, and they would get paid in full. So anything they would have gotten pre-petition, they would have gotten in the Chapter 7 also. So it's considered not a preference. Now, there's a catch here. The creditor would have to have received this much in a Chapter 7 from the debtor. That doesn't mean if you have a guarantor who's, well, in a Chapter 7, I would have been paid by the guarantor. No, that doesn't qualify. The creditor would have had to receive as much from the debtor in a Chapter 7. If you have a guarantor that would have paid you, well, that's great. You may still be able to go after them later, but you're still potentially liable for the preference. And this may sound like it goes without saying, but check the payment dates. If a payment wasn't made within 90 days, it's not a preference. And this happens every so often. Somebody sues and you look at the calendar and it doesn't qualify. Now, thing to know that in the United States law, under the Supreme Court's rulings, for a payment to be a preference, you look at the date the check cleared, if it's a check. So I have had creditor or defendants say, hey, look, I got paid in 92 days. I got the check in 92 days, but they deposited on 91 or 90, and it doesn't clear until day 89. Well, sorry, but under Supreme Court law, that there's nothing you can do about it. That still qualifies as a preference. You can't get out of it that way. So about defenses. Well, there's a number of different defenses that are out there. Some of them are too small. We won't go into them. For example, if a preference is for total collective preferences under 7,500, I think it's 75, it won't qualify as a preference. So, but those don't generally affect most people. The main ones that affect people are contemporaneous exchange of value, subsequent new value, and ordinary course. And we'll delve into more detail in subsequent new value and ordinary course in the coming slides. But let's start with contemporaneous exchange of value. Something is not a preference, or you have a defense to it, if the transfer was intended to be a contemporaneous exchange of value and was substantially a contemporaneous exchange of value. What does that mean? Why does that have to be intended and substantially be one? Congress wrote this because of checks. If somebody has a COD delivery, for example, cash on demand, and they pay by check, it's intended to be a contemporaneous exchange of value. Somebody gets the goods, they hand over a check, right? Now, the way the law works is that check you can't immediately spend the check, you have to deposit it. It takes a day or two to clear. So in that kind of situation, if it's intended to be contemporaneous, but it takes a day or two for the check to clear, so it's only substantially contemporaneous, it's still considered a contemporaneous exchange of value. Where people get in trouble is they try to read into this and get cute. Well, if it's got to be substantially contemporaneous, well, you pay me a day later. If the intention is to pay 1 day later, it's not intended to be contemporaneous. It doesn't qualify. And I've seen this very often where people say, well, but I kept it really short. The answer is you can't keep it really short. It's got to be intended to be the same time, but it just isn't because of some mechanism of the payment. And even then, the mechanism has to be substantially contemporaneous. You have situations where somebody gets a check, for example, and they don't deposit it for 2 weeks. And they don't deposit it. And then when they finally do deposit it, it clears. It's no longer, it may have been intended to be contemporaneous, but it no longer is substantially contemporaneous, and you got a problem. So that's the contemporaneous exchange of value. It doesn't come up as often as people think it should because of the way it's drafted and because of the way it works. The two big ones that come up are subsequent new value and ordinary course. Now, subsequent new value is a very simple concept, and the idea is that once the creditor receives something, they give something back so that the estate's replenished. That's the idea. And the idea of it being replenished means that if I give whatever I give back, it can't itself have been paid for or somehow not avoidable itself. And that leads to a situation, what we call the 503b9 issue. 503b9, it refers to Title 11, Section 503b9. And this is something Congress passed in 2005. Congress had the idea that debtors were ordering all sorts of goods in advance and not paying for them. They'd avoid them, order them, and it would be like within the 20 days or so, they'd ramp up their inventory, and then they'd declare bankruptcy and then fund the estate by selling off this inventory. Now, I haven't seen anything that says that really was an issue, but doesn't matter. They passed the law. It's a very strict, narrow law. You have to have actually received goods. The debtor has to actually have gotten them, not at a warehouse, that it can get access to or something. The debtor has to have actually gotten them. They have to have actually been received within 20 days. It has to be goods, not services. I guess they're worried about something that could be resold. But if those all are true, then those goods, for a debtor to confirm a plan, it's got to pay for them in full, because it becomes an administrative expense, a cost of administering the bankruptcy, and must be paid in full. So they often are paid in full, especially in Chapter 11 bankruptcies. Well, what happens here, we talked about the replenishment for subsequent new value. A lot of debtors will argue, and have successfully argued in some cases, that because the debtor has to pay for them, then you're not replenishing the estate. Now, creditors have been quick to point out, well, that's not right. First of all, I don't know if it's going to be a 503b9 when I issue something. I don't know what yet. It's got to be within 20 days of the petition. I don't know when the petition date's going to be. And I'm not sure I'm going to even get paid for them. Who knows if a plan's going to get confirmed? And so there's case law that goes the other way. So you can see how this leads to kind of a mess. So the subsequent new value defense is subject to a few interesting quirks that may be a problem. And we'll talk about these a little bit more in a moment. The other main defense we talk about all the time in preference work is the ordinary course defense. Something is an ordinary course payment if it was in payment of a debt that was incurred in the ordinary course of business between the parties and either paid as ordinary between the parties or as ordinary to the industry generally. Now, again, there are other exceptions that apply, but these are the big three. So let's talk about subsequent new value and look about how it works. So here's an example. Suppose that I am a vendor to a debtor, and the debtor has not yet filed. They pay me $10,000. This is going to be within 90 days. None of us know yet it's going to be within 90 days because no bankruptcy has yet been filed. But nonetheless, I get $10,000, and I ship out some new goods a few days, a little bit later. Now I ship out $15,000 worth of goods. This is more than I received in value. So my preference exposure is reduced to zero. I don't get a credit beyond the amount. It's just, I have no preference exposure. Then I get another $10,000 and I ship out $5,000 worth of goods. And then the debtor files. My net exposure is $5,000. Now, some people say, but that's not fair because I got 20,000, I put out 20,000. You hear this all the time. But I got to remember, this is subsequent new value. The timing is really important. And, you can imagine all sorts of different spins on this that can change how the outcome works. But this is a defense that works extremely well for people who have lots and lots of transactions because you have a lot of back and forth, and that tends to help, net out preference exposure. Now let's take a look at the same idea or similar idea, but change the numbers a little bit. Let's say I ship goods and I ship goods and I ship goods, and then they pay me $10,000, and then they file shortly thereafter. There's nothing subsequent. My exposure is $10,000. Doesn't matter that I've given out $45,000 worth of goods first. There's nothing subsequent. It's called the subsequent new value defense for a reason. Timing is everything. And, unfortunately, you explain this to people, but this is what Congress wrote. This is what it is. Ordinary course. Now, again, there's two real components. One, how the debt was incurred, and one, how it was paid. The first of them really almost doesn't count because almost always a debt is going to be incurred in ordinary fashion. Especially in vendor relationships, somebody orders goods, they have a debt for it. This is considered normal. In theory, I suppose one could defend on saying the debt was not incurred in ordinary fashion, but I have not seen it. And I've done hundreds, if not 1,000 of these things yet. So we've not seen them yet. I wouldn't worry about that. What you worry about is whether the payment was ordinary between the parties or ordinary in the industry. Now, ordinary between the parties, you take a look usually at invoice dates, and you take a look at how long it took to pay invoices. Now, if you really want to get nitpicky, often it's not just the invoice dates. You can go as far down as the dates actual goods were shipped or the dates services were provided. So you can get really, really fine-grained. But it's often very difficult to get that data. The trustee doesn't often have it. So a lot of times people just use invoice data as a reasonable substitute for when things took place. And you just take a look at how many days it took to pay within the 90-day period. That's in the preference period, the 90 days pre-petition. And you compare that to some earlier period. Now, that earlier period's got to be long enough for people to tell the convincing story, essentially. Sometimes people say, well, can I show you like 2 months worth of stuff beforehand? Well, think about yourself. Would you be convinced if you had 2 months of data and then, comparing that to 3 months of, activity pre-petition? Maybe, maybe not. You're trying to sell the judge. You're trying to sell the other party. More is better. If you can show that over the past 3 years, this is how long it took on average for people to be paid, and then look, it's exactly the same transfer by transfer. You check each transfer within the preference period, and they all look about the same as in the preceding 3 years. People kind of buy that. That's what the defense is all about. There's different. I won't go into all the different ways you can do it. One way you can show like an average and then show standard deviation, which captures about 2/3 of transactions around the average. You can use weighted weeks. You can use straight averages. There's all sorts of things. You can use bucket analyses, histogram analyses. And I've used all of them depending on what the circumstances show. You just basically have to be able to tell a good story showing that indeed the transactions were ordinary between the parties. And if you can do that, then again, you have a defense to the preference. The defense means it technically is a preference, but it's defendable and it can't be recovered. Now, if you want to show something's ordinary in the industry, that's a bit harder. Because ordinary in the industry means the parties have to show, or usually the defendant, the creditor, has to show industry's data that it generally doesn't have by itself. So it needs to get an expert. Sometimes, a few times, if you have somebody who's really well-versed and has lots of experience in the industry, has been practicing for many years, you can get a declaration from that particular person and saying, I'm familiar with everything and I can say this is the average. Yeah. But I have found that debtors are not usually terribly swayed by that because they know that if you get in front of a court and they bring up an expert to say something counter, you have one person testifying, in I want to say self-serving, but technically that's how it would be viewed, a self-serving capacity versus an expert who's dispassionate. The expert's going to win. So generally, you need to hire an expert of your own, and they will go to RMA, which is one of the, we're having a session with them, the mixology session next month. The Risk Management Association maintains data on how often it takes, and industry by industry, how often it takes to pay invoices. They do it by quartiles. You can buy the report, the expert can put together a report and show that. They can look at Dun & Bradstreet. There's all sorts of different sources out there an expert can access, and they will put together a report. The problem, of course, is expert reports tend to be expensive. It used to be 5 years ago, I could get them for $5,000 for a client. Now it's more like 10 or 12 or 15. So you're not going to be using ordinary course in the industry to defend a small preference. It's just not feasible. Now you can use these two together. Remember that subsequent new value will work with anything as long as the value that's given is not defensible on some other means. So if a transaction, a transfer, a payment on an invoice is defensible under the ordinary course, you can't include that invoice and the goods included in it or the services included in it in a subsequent new value analysis. But there may be bits that are not included in the ordinary course defense, and you can see if subsequent new value helps you there. And we do this all the time. So, pleading practicality. Maybe something's a preference. Maybe there are no defenses. What are you talking about? Maybe the defendant's in another jurisdiction, China, Poland. If you have to go, if the debtor has to go overseas to sue, or maybe they think they can sue in bankruptcy court, but they have to go overseas to collect on the debt. The odds are pretty poor that it's going to get anything. And really, they're working under the clock. They don't have forever to go after something. They don't have 3 or 4 years normally, unless you're Sears. You don't have a long time. So they're going to want to do something relatively soon. And, seeing that it's another jurisdiction will indeed, deter people. Even Canada is not that far, our neighbors to the north, but you have, service issues and all sorts of things that can complicate recovery. And, that might be enough to get you a break on what you have to pay. Or if the defendant has no money, that's a reason not to pursue right there. Or if there's something complicating for the debtor, the debtor has to prove something specific, that would be a fact-dependent reason. But if there's reasons for the defendant or for the debtor that would make it difficult for the debtor to collect, well, that's a good reason to negotiate, isn't it? Bring them up early and bring them up often. Now, remember, avoidance doesn't get you money. You have to actually recover under 550. And one of the things 550 says is the trustee or the debtor may recover for the benefit of the estate. Now, is it going to be for the benefit of the estate or perhaps for somebody else? You'll find creditors, secured creditors in particular, will sometimes get a lien on for securing use of cash collateral. They'll get a lien on Chapter 5 recoveries, which are basically Chapter 5. These are Section 547, Section 548, 549. These are called Chapter 5 actions in bankruptcy. If the secured creditor has a lien on them, and if the benefit of any recovery is for the secured creditor, you might argue that this is not for the benefit of the estate, it's the benefit of somebody else. Not a common defense, but it is something to keep in mind. Who benefits if this money is recovered? Also, and this is more bad news for the Celsius cryptocurrency people. We said we're going to come back to this. Remember, Section 550 allows a debtor to seek return of the property, or it can ask the court to allow it to seek the value of the property. Can ask to seek the value. Now think about the people who tried to get out of the Celsius bankruptcy before Celsius actually filed, because they knew something bad was coming and they got out. Bitcoin is now, I think, around $18,000 or $19,000. I haven't checked this morning. It was maybe around 18 or 19 when Celsius filed, but it was up higher prior to that. So if you withdrew in April, for example, it was probably worth about $35,000. So let's say you're a Celsius customer in an earn account, you had 2 Bitcoin, you withdrew them and they were valued like $35,000 or $38,000. So you have like $70,000 worth of value you took out in April within the 90-day period. And then you think, oh, I'm free and clear. And you kept it, you still have it, and you rode the value all the way down. So now it's only worth, your 70,000 is worth maybe 38, 39. And you get a lawsuit, a preference lawsuit, and they're not seeking to get that Bitcoin back. They want the 75,000 or whatever it was worth when you took it out. So basically, you're screwed. You're now basically being held accountable for the decline in value. That's a very real proposition that people could be facing. Whether or not Celsius is going to do that is another story. If they're going to try to sell the business and try to have any kind of hopes of having the new owners have any credit with new customers, they may not do that, but it's certainly something that the current statutes allow, because it's designed for the purpose of when you have property declining in value. And what declined more quickly than cryptocurrency between, say, April and this summer? Something to be aware of. We put an article out, or a short article out, alerting people to this problem not too long ago. So that's preferences in a nutshell. Let's talk about fraudulent transfers. So we talked about this is coded in the bankruptcy under sections 548 A1A and A1B, and also 544B allows you to use the state law on fraudulent transfers. In Michigan, it's called the Avoidable Transactions Act. So that's what you would call it here. Now, what qualifies as a fraudulent transfer? Now, we think, a debtor transferred something to a non-debtor to keep it safe from creditors, but there's other things that can qualify as a fraudulent transaction or fraudulent transfer. And I wrote an article, as you can see at the bottom of the screen, can you spot a potential fraudulent transfer, in the Michigan Business Law Journal back in the spring of 2018, a few years ago. A number of things, if the debtor transfers an interest of its property for less than reasonably equivalent value, a lot of things can qualify. Lease terminations, if the lease is of value, especially when does a lessor try to terminate a lease? Well, it's when it thinks that the lessee, the debtor is about to file, not going to get any money from there, and somebody else is waiting in the wings. This thing has value, I'd like to put it back into play. Well, that very releasing kind of demonstrates the value that this lease had. And so if you transfer the lease, from the debtor by terminating it, and you give it to somebody else and basically demonstrate the value that was there, that can be qualifying as a fraudulent transfer. And people get sued on it. It's in my article, you'll see that. Asset sales and foreclosures, guarantees, dividends. If people are giving away debtor assets, or if the debtor is giving away its assets or transferring them and not getting reasonably equivalent value, these kinds of things can qualify as a fraudulent transfer. So there are things you wouldn't normally expect that you got to keep an eye on. Now, if you're defending one, you got to see, is it a transfer of the debtor's property? Did whatever was transferred, did it really belong to the debtor? If it was an earmarking, maybe, we talked about before, earmarking for preferences works just as well here. If the money transferred, if it was money, did not belong to the debtor, then it can't be a transfer of the debtor's property, and it's not a fraudulent transfer. Was the debtor really insolvent? Was it unable to pay its bills? Remember, for preferences, there's a presumption that the debtor's insolvent in the 90 days pre-petition. That does not apply here for fraudulent transfers. The debtor has to prove that it was insolvent. And sometimes, even though, everybody knows it's insolvent, everybody knows is not legal proof. You have to have something, and maybe the debtor doesn't have any evidence, actual evidence, except from word of mouth, which, doesn't count for a whole lot, to show that it was insolvent. If they can't show, the debtor can't show that it was insolvent, then it can't easily recover a fraudulent transfer. And the fact that it became insolvent later doesn't render the transfer a fraudulent transfer. It's got to be when the transfer took place. And that's something you need to be aware of. Debtors will conveniently kind of look over that if they find it inconvenient to discuss. Also, again, remember talked about the situation with my daughter and her car, whether she gave it to a friend or she sold it. The same situation applies here for 550. If the person to whom the property was transferred didn't keep the property, did the subsequent transferee take for value? Did they pay for it? If they paid for it, that they, in this case, bought the car, for money, then it's probably you can't go after them. But if they didn't, and if a real fraudulent transfer where people are trying to hide the ball, there's a lot of transfers that take place often without value. So you can follow the chain. It's something, but you need to be aware of what were the transactions, and you have to know a little bit more than you might for a preference to figure out all the little connecting points. All right, back to cryptocurrencies, right? There's been news reports saying that FTX, which recently filed, it gave money to political groups and charities. Could that be clawed back as fraudulent transfer? Well, under 528A2 and D3, there's an exception for charitable contributions, but it probably isn't going to help FTX here, because to be a charitable contribution as defined within the code, it's got to be made by a natural person, not a corporation. FTX won't qualify. Now, its board members could have given money away, but that, so those could qualify. But even there, it can't be more than 15% of the annual income of the board member. So if they try to give away a lot of money, even that won't qualify. I think 15% was picked because a lot of religions have a concept of tithing, paying 10%, and that comfortably fits in. So normal contributions can't be clawed back, but the kind of stuff that FTX was probably doing, yeah, probably. Plus, to be a charitable contribution, it has to qualify as cash, which, cryptocurrency is not cash. It has to be, or it could be a financial instrument under the IRS code. And I gave you the statute site there. It's not entirely clear that crypto, if somebody donated crypto, like if FTX donated Bitcoin or Ethereum or something, it's not clear that that would be a charitable contribution that would qualify. So my belief is, it's not been tested yet. My belief is that, yeah, the charitable contributions are going to be recoverable under most circumstances, because again, FTX is not going to get any reasonably equivalent value. So it's probably going to qualify. Same thing with political donations. You don't have any kind of cover at all for that. And I would really love to see FTX arguing that it got reasonably equivalent value from a political donation. So how much was that politician worth when you bought them? Yeah, I think that's going to be a problem for political campaigns. Of course, if they donate it to a political campaign and they don't have the money anymore because they spent it all on advertising, we have that pleading practicality issue that's going to, we talked about earlier. So settlement, you've gotten through, you guys kind of agreed upon where the transactions lie. What do you do when you start thinking about settlement? Well, first thing to remember, 11 USC 502H. 502H, we call them 502H claims. Remember, this is where understanding how preferences came to be helps with understanding how you settle them. Remember the beginning idea? If you have a preference, wouldn't it be great if everybody kicked the money back into the pot and all creditors shared equally in the pot? Well, this is the share equally part. If you give money back, then you're supposed to get a claim that you can file within 30 days of the settlement for the amount of money you paid. Technically speaking, it's a claim for, you have a 502H claim for a judgment, but nobody really quibbles about giving you a 502H claim for a settlement in lieu of a judgment. So this is how you get the money back. So if I pay $25,000 to settle a preference, I ought to get an unsecured claim for $25,000. Now, what is that worth? In many cases, not much. If unsecured claims, if they're going to spend, debtor's going to spend all this money and it's going to use it to run the case, there's not going to be any money in the pot to give to people. So maybe it's worth 1 or 2%. We really don't care. But if it's worth 50% or 60% or 30%, and that happens, then you have a couple choices. You could just file the 502H claim, or maybe you take advantage of that during the settlement. You come to an agreement on what the preference is, and then say the preference is $25,000, but if you know it's going to get paid, the debtor is estimated in its plan that people are going to get 50% recoveries, then maybe you say, how about I'll waive my 502H claim, but instead of paying you 25, I pay you 12.5. And sometimes they'll do that. Often they'll do that. And it keeps you, it means one less step for the defendant, because the defendant no longer has to go and bother filing a proof of claim. They get it all in one shot. Other things to be aware of. It depends on who your debtor is and the legal team they hire. Most settlements are pretty fair. If anything, I've found with settlement agreements, I found they tend to be sloppy. They get case numbers wrong. There's like little typos in them that you should be fixing. And a good attorney really should look at them. Or if you don't have an attorney, you should read them carefully and check anything they say just to make sure that they're saying it properly, because they screw up. But there's sometimes they try to sneak stuff in, and that's the stuff you want to watch out for. Sometimes they'll say, okay, and as part of this, you waive any claims you filed in the bankruptcy case. Now that can be a big deal. Let's say you had a $200,000 claim that's going to be paid at, say, 20%, right? So it's worth 40 grand. And you have a $30,000 preference that you're suing for 10, you're settling for 10 or something. So you settle for 10 and they want you to give up $40,000 worth of claims. Nuh-uh is the legal response for that. We don't give up claims just because we settled, because there's no value for that. So you want to make sure that, unless you've agreed that that's part of what the contribution is, that's part of your payment of your settlement, you want to make sure it's not just thrown in there because they could have some value. Oftentimes they don't. And so, that's fine. but at least be aware. And if they don't say, if they just put it in, you might want to ask them, so what is the expected recovery? And where can I check that out? Oftentimes that's in the disclosure statement if it's a Chapter 11 case. Waiver of claims not filed against but held against third parties. They sometimes want you to waive claims against affiliates or guarantors. And maybe you have a valid claim for payment in full against a guarantor, for example. Don't give that up. As you know, oftentimes, if the guarantee claim says that you can even get recovery if you pay it back, that might be your way to recover the preference. So be careful to make sure that the settlement doesn't have any benefits for a third, against, in favor of a third party and against you. Debtors sometimes will only waive the claims that are specifically alleged. There's really not much you can do about this, but I tend to say, look, if you want to settle something, let's settle all Chapter 5 cases together. You're suing me for preferences. Let's sue all Chapter 5, all preferences, fraudulent transfers, post-petition, because we shouldn't be doing this again. It does not happen often, but I have seen a trustee or a debtor sue twice. Once on a certain set of claims, and then after they realize that they didn't check the books and records properly, a second set of claims they want to bring, sometimes bigger than the first. And to me, that's on the debtor. If the debtor wants to bring it all at once and get it over with. And you also want to make sure that the debtor's not having you make any representations or weird indemnifications or whatever in the settlement. If you do enough of these things, you'll see all sorts of weird stuff thrown into settlement agreements. Just read them, make sure you understand them, and don't agree to anything that doesn't make sense. How can you prepare as a business person? Well, be diligent. If you have repayment terms, enforce them. Because remember, the ordinary course defense says if you pay during the preference period, or you get paid during the preference period in a fashion similar to how you were paid previously, then it's not a preference. That's the ordinary course of business defense. And although debtors like to say, oh, but you pressured me during the preference period, you pressured me. Well, if you've been pressuring them the whole long, there is case law that says that's fine, as long as you didn't do something different during the preference period. So if you have if you have payment terms, have them followed. If you normally would call on 3 days, it says, I'm going to call you if you don't pay within 3 days of the payment, call them. So that way, if they later on file, you can say, look, here's my documentation. I've always called you. I've always done this. There's nothing unusual about it. And you want to be able to demonstrate that, because during a preference case, it's what you can prove. So it's not just a matter of doing it, but documenting it. You can also switch to prepayment or COD terms if your contracts allow. So one thing you might want to do is, if you have contracts, you might want to have a term in there that says, if I get uncomfortable with your creditworthiness, I can switch from my net 30 terms or whatever I normally offer to prepayment or to COD terms. If your contract allows it and you do it, now that's going to destroy an ordinary course of defense, from that point forward, because nothing after that is ordinary, right? You've switched to prepayment, but any money you receive after on prepayment terms will not be a preference. And arguably anything up to that point could very well still be ordinary. So, now if you get money, if they repay some old debts during that time, yeah, they're going to be preferences, but c'est la vie, you can't fix everything. So again, consistency is key. Any pattern works as long as it's consistent. And final note, I've had people call me every so often and say, look, I'm offered this thing. They tell me, I know they're going to file, they're going to pay me. Do I want to maybe not pay it so I can avoid the preference lawsuit? My advice is to people, if you're offered money, you take the money. As long as it's, not a bribe or, legitimate payment on the debt, take the money. Yeah, sure. Maybe it's a preference, but maybe it won't be. A, maybe they won't file bankruptcy. B, maybe they file bankruptcy and they don't file preferences. C, maybe they file preferences, but not against you because yours isn't big enough. D, maybe they file a preference case and they file one against you, but you can always give some of it back. So let's say you settle your preference for 80% without doing anything. You say, look, I'll give you back 80% of it, and I get a claim for 80%. You still got 20%. And if unsecured claims are being paid at a rate of 5%, you're ahead of the game. So general rule of thumb, if somebody offers you money, you say yes. Spoken like a true creditor's attorney, what can I say? Fraudulent transfers, same idea. Be alert. If you're taking an action because the other side is in a financial difficulty, do consider that it's possible that this could be construed as a fraudulent transfer. If that's the case, you want to document what value you're providing, because you want to be able to prove later that there's some value that's been given to the debtor so that you can show it's reasonably equivalent. But remember, don't reorder everything. Don't change all of your normal business transactions just to avoid a fraudulent transfer. Sometimes there's nothing you can do. And we talked about in the preference case, it's always better to have the money because not everything will ripen into a lawsuit. So that really covers, I think, in within 1 hour, we're still 4 minutes before the hour, a whole list of preferences and fraudulent transfers. I do not see any questions. I'll keep the line open for another few moments to see if anybody has any. I'm hoping I haven't put everybody to sleep. All right. Well, I'm not seeing anybody typing. It sounds like we've covered all the things we set out to cover. So I thank you for joining me today. I hope you found this useful and interesting. And like I said before, my email is spinner@millercanfield.com. If you run into questions later that you think, oh, I should have asked, then feel free to send me an email. Or if you want a copy of that Decrypting Crypto article and can't get it from Norton's Bankruptcy Journal, send me an email and I can help you out that way. Thank you very much for joining us and have a great day. Oh, I see a Q&A just came up. Oh, thank you. All right, well, I can